I am Hank Chambers, and I'm a law professor at the University of Richmond.
Judge.
I'm Steve Levinson, and I watch movies anytime I want, and I watch them cheaper than you get to. But before I did that, I was a state Supreme Court justice in Hawaii.
And my name is Jerry Bass. I don't get to watch movies quite as cheap as he does yet because I'm still working. I'm a district judge in Oklahoma. Been doing that for about 15 years, and my colleagues to my left and my right, we've done this, each of us done this about 4 times at the national finals, and it's just, I think I can speak on behalf of all of us, it's just really an honor and a privilege to be here with you all today. It's really a highlight for all of us. So please introduce yourselves.
Good morning. My name is Ankita Panda.
I'm Julie Mond. I'm Kathy Yam.
Hi, I'm Freya Heftiker, and this is our teacher, Mr. Broadman.
Okay. Good morning. This is Unit 5, and this is question number 3. We need procedures that translate the values of the Fourth Amendment with its warrant requirement into a new technological context. Do you agree or disagree with this claim by a legal scholar, and why? What values are inherent in the Fourth Amendment, and why are they important? Some scholars argue the government can use surveillance data collection and data mining technologies for good purposes, such as keeping Americans safe from terrorist attacks, preventing crime, and delivering social services. Do such uses outweigh possible negative uses? Why or why not? And you may begin.
We agree that the values of the Fourth Amendment should be translated into new technological context because, according to Justice Scalia, it would be foolish to contend that the degree of privacy secured to citizens by the Fourth Amendment has been entirely unaffected by the advance of technology. The protection of an individual and his property should apply to wireless communications as it applies to all physical evidence. According to Katz v. U.S., the Fourth Amendment protects people, not places. This protection adheres to situations which exhibit an expectation of privacy. According to Justice Bradley, the government's offense is the invasion of the indefeasible right of personal security, personal liberty, and private property. We agree with Ohio State v. Smith, in which the Ohio Supreme Court ruled that users have a higher level of privacy for their cell phones since they store large amounts of private data. We also agree with State v. Reed, in which the New Jersey Supreme Court ruled that the exclusionary rule applies to Internet evidence and held that there is no material difference between the ISP's subscriber information and bank records. The First Circuit ruled in U.S. v. Councilman that emails and electronic communications also receive Fourth Amendment protection.
Values inherent in the Fourth Amendment include justice, equality, limited government, rule of law, freedom, privacy, and security. According to Justice Jackson, the Fourth Amendment upholds justice by requiring that inferences are drawn by a neutral magistrate. Justice is important since it promotes equality, impartiality, and fairness. The Fourth Amendment helps assure limited government and individual privacy by setting parameters on when the government can conduct searches and seizures by requiring probable cause. Limited government and privacy actuate freedom and protect against governmental abuse since, as Justice Brandeis stated, the Fourth Amendment protects the right to be free from unjustifiable intrusion by the government. The amendment also protects security since it enables the government to conduct reasonable searches and seizures to keep the community safe. In U.S. v. Alcott, the Ninth Circuit upheld an airport security screening process.
We believe the benefits of government surveillance and data mining do not outweigh the possible negative uses. Warrantless government surveillance is not in the spirit of the Constitution. According to Justice Douglas, the Fourth Amendment tells us it is better that the guilty sometimes go free than the citizens be subject to easy arrest. U.S. v. U.S. District Court ruled that the Fourth Amendment requires the President to obtain a search warrant before conducting surveillance activities. While we agree with California v. Sorello that surveillance in public areas is not a violation, we agree with Justice Harlan, who noted that individuals are protected in locations where they have an actual expectation of privacy. Surveillance can chill political activity and dissent by discouraging individuals from associating with controversial political groups. According to Justice Powell, the danger to political dissent is acute where the government attempts to act under so vague a concept as the power to protect domestic security. In Maryland, the state police monitored local anti-war and anti-death penalty groups and placed 53 peaceful activists in terrorism-related databases.
In U.S. v. Trung Den Hung, the Fourth Circuit ruled that the president could not authorize surveillance if its primary purpose was to find evidence of a crime, because the Fourth Amendment requires probable cause. As stated in the federal report on the President's surveillance program, warrantless government surveillance ultimately plays a limited role in the FBI's overall counterterrorism efforts. According to the Cato Institute, data mining needlessly infringes on the privacy and civil liberties and misdirects the time and energy of the national security community. Data mining is arguably worse than standard surveillance because it searches for patterns in large samples of ordinary people's computer data without a specific target. It addresses profiled citizens rather than identified wrongdoers. Government surveillance can also lead to the abuse of power by government agencies. Under the Bush administration, the FBI illegally obtained thousands of Americans' telephone records by claiming false emergencies.
Would you have an issue with the government's data mining 12 hours prior to 9/11?
I think the primary issue with data mining is that it's targeting innocent people, and it's using innocent people's information to create profiles to find people who may have committed a crime by looking for aberrations and patterns. And I think that this goes against the entire values of the Fourth Amendment, because as stated by James Otis, a man is free from intrusion of the government in his house while he is quiet and while he is not committing a crime. And therefore, I think that when people are not committing crimes and they're completely innocent, there's no reason for the government to be conducting these data mining activities.
Now, are they mining public information or are they mining private information?
I believe that data mining private information is not feasible under the Fourth Amendment, because I think the Fourth Amendment's values that underlie it is to protect the person from governmental intrusion. I believe that data mining, although sometimes necessary under national security, some may argue, is not feasible because there are a lot of innocent people whose rights are being violated if one looks at their personal information.